Good afternoon and welcome to you all. My name is Alan Robertson, President of the Australian Academy of Law. I particularly welcome Her Excellency the Honourable Margaret Beazley, ACQC, the Governor of New South Wales and a Fellow of the Academy of Law. We are honoured by her attendance. It's my privilege and pleasure to introduce tonight's event in what I hope is becoming a tradition. This is the third joint event between the two academies. The first in 2018 had the title, Are You Sure?, which included the relationship between probability for the purposes of litigation and statistical probability, human memory, the embracing of uncertainty. If you like, it has some relationship with what is going to be spoken about tonight. The second of the joint events last year had as its structure a hypothetical set of facts on climate change, and the participants spoke about the law and the science. Tonight's event is, as you know, the reception, quality and evaluation of scientific evidence in Australian courts. It is the first one to be conducted remotely. The number of registrations for this event to me is astonishing. At last count, it was at or over 800 people. I will not introduce the speakers, as the chair will do that in a moment. I would like, however, to spend a minute introducing our distinguished chair for this evening, the Honourable Justice Virginia Bell, AC, a Justice of the High Court, indeed the senior puisne judge of that court. We are privileged that she has agreed to chair this event, and I thank her for that. Justice Bell was appointed to the High Court in February 2009. At the time of her appointment, she was a judge of the New South Wales Court of Appeal, having been appointed to that court in early 2008. Justice Bell was earlier appointed a judge of the Supreme Court of New South Wales in March 1999. She graduated from the University of Sydney as a Bachelor of Laws in 1977, and after 7 years as a solicitor with the Redfern Legal Centre, she was admitted to the New South Wales Bar in 1984 and appointed senior counsel in 1997. Justice Bell practiced as a public defender between 1986 and 1989 before returning to the private bar. Between 1994 and 1997, she was a counsel assisting the Royal Commission into the New South Wales Police Service. She served as president of the Australian Institute of Judicial Administration from 2006 to 2008. She has been awarded honorary degrees from the University of Wollongong and the University of Sydney. Ladies and gentlemen, I won't say more as time is pressing, but I pass you over to Justice Bell.
Thank you for that, Alan. What can I say for this third collaboration between the Academies of Law and Science? We have assembled an impressive panel who are well placed to address the issues around the reception, quality and evaluation of scientific evidence in Australian courts. The focus on the discussion this evening will be on the reception of scientific evidence under the provisions of Section 79 of the Uniform Evidence legislation. That legislation reflects the draft that was appended to the Australian Law Reform Commission's landmark report on evidence in the 1980s. And in some respects, Section 79, as you will hear, departs from the common law. Narrowing the focus even further, the participants will be addressing their remarks to issues that are of particular relevance in the conduct of criminal proceedings. It's intended to start off broadly with a paper that's been prepared by Justice Mark Weinberg of the Victorian Court of Appeal. I expect that Justice Weinberg requires little introduction, certainly to the registrants whose background is legal. At the bar, Justice Weinberg had a wealth of experience in the conduct of criminal cases, culminating in his appointment as the Commonwealth Director of Public Prosecutions. He has served as a judge both of the Federal Court and the Court of Appeal of Victoria for more than 20 years. Justice Weinberg is going to tease out some of the issues arising from the choice in our uniform evidence legislation not to impose a test of reliability on the admission of expert opinion evidence. Justice Weinberg will be followed by Professor Peter Balding. Professor Balding is the Professor of Statistical Genetics at the University of Melbourne. And in this context, he will be well known both to his scientific colleagues and to members of the legal profession for his work on the evaluation of forensic DNA evidence. Professor Balding is going to pick up from Justice Weinberg by discussing problems with the quality of forensic science evidence, drawing amongst other things on the United States experience reflected in 2 major reports, and on Professor Balding's own experience as an expert witness, particularly in the United Kingdom. Next, and sticking with genetics tonight, we're going to hear from Professor Carola Vinuesa. Professor Vinuesa heads the Department of Pathogens and Immunity at the College of Medicine at ANU. Professor Vinuesa's interest in the topic of tonight's webinar was prompted by her involvement in the inquiry which was established in August 2018 into the safety of Kathleen Folbig's conviction for the manslaughter of 1 child and the murder of 3 further children. Professor Vinuesa gave evidence on Kathleen Folbig's behalf before the inquiry and participated in conclaves with experts called by counsel assisting. She's one of the authors of a paper on the case titled Infanticide versus Inherited Cardiac Arrhythmias and the Fine Line Between Guilt and Innocence. The inquiry received a deal of evidence from geneticists about the developments in genetic science in the period since Ms. Folbig's conviction in 2003. Professor Vinuesa intends to speak of her experiences in giving expert evidence and concerns that she was left with about the reception of that evidence. Finally, Tim Game, Senior Counsel, currently the President of the New South Wales Bar, a person with lengthy experience in both adducing expert evidence on behalf of the prosecution and the defence at trial, and in challenging it or defending it on appeal, will speak of his experiences, including in what on occasions has been undertaken in criminal proceedings involving conclaves of experts. The format of tonight's webinar will be that each speaker will speak for approximately 15 minutes. At the conclusion of Tim Game's presentation, there's going to be an opportunity for questions. Registrants are able to ask questions by typing them into the question and answer panel that I understand you will see on your screen. And I'm told that this technology enables people to upvote, which sounds positively Trumpian, but I gather includes the capacity to simply put an emoji thumb on your screen signifying approval to a question, and that will move the question up in priority. Finally, can I tell you that the event is being recorded and it will be available for those who are interested in viewing it afterwards. Without more, may I call on Justice Weinberg. Thank you.
Thank you very much, Justice Bell, and good evening, ladies and gentlemen. It's a great honour to have been asked to take part in this panel discussion. I am well known as being a contrarian. I was asked to provide a list of dot point for Justice Bell to appreciate what we were going to say, so I promptly wrote a lengthy paper. The paper that I have written will be available to anyone, I imagine, in the next day or so if they haven't already had the opportunity to read it. but I will speak to it in very general terms. There are three matters that I've addressed in the paper. The first is the somewhat provocative expression junk science, which is not my term. It was a term devised in the 1980s and picked up and applied by the United States Supreme Court. So it has a legitimate legal pedigree, if I can put it that way. The second matter that I'll deal with is the notion of judges as what are called gatekeepers. I'll be addressing that issue, which I think Justice Bell has adverted to, the question of reliability as being a condition precedent to the admission of opinion evidence in scientific matters. And finally, I will tell you a little bit about my own experience as both a barrister and a judge in the area of DNA evidence, which I think falls into a quite separate category to all other forms of scientific evidence, and most definitely is not junk science. All right, well, junk science. Until comparatively recently, I think, like most of you, I would have had the same assumptions about scientific evidence in criminal cases that we get from watching television programs. The assumption that the scientist can switch on a computer and put through a program and come out with a definitive answer in a case where, say, identification is an issue. Fingerprint evidence in my time was described as the gold standard. It was presented in a way that made it look scientifically incapable of being impugned. We had large screens, charts, whorls and ridges and so forth, all with indications addressed by pointers, sometimes laser pointers, but it all looked extraordinarily scientific. Until comparatively recently, I would have thought that this was an area that could not legitimately be characterized as junk science at all. I was astonished several years ago to read some papers indicating that there had been research done, particularly in the United States, which cast doubt upon even the gold standard of fingerprint evidence. There had been cases where wrongful identifications had been made, a number of them. People had been wrongly convicted on the basis of fingerprint evidence. And I then inquired a little further into the area and discovered that the United States in particular had produced a number of investigations and reports. One has been mentioned, the 2009 National Academy of Sciences report, Strengthening Forensic Science in the United States, A Path Forward. This is a pivotal, a seminal report. And if you get the chance to read just one chapter, it's a very lengthy document, but chapter 5 is an utterly destructive document, very critical of the way in which some forms of forensic scientific evidence have been presented in American courts and the miscarriages of justice that have arisen. It singles out for particular criticism mitochondrial DNA, which for those of you who have not heard of the expression is a form of DNA which is based upon hair analysis generally, tool mark identification and fiber analysis, but it also criticizes strongly shoe print and tire track analysis, handwriting, forensic odontology, which is bite mark evidence, largely speaking, and even paint and coatings evidence. All of these areas of science were the subject of lengthy investigation by this National Academy of Sciences report, and the critique is very powerful indeed. I had the benefit of reading a wonderful paper by Judge Jed Rakoff in the New York Review of Books, and I refer to that in footnotes and so forth. Judge Rakoff is provides a devastating critique of some of these areas. The 2009 report led to the establishment in 2016 of a commission which went into this area in even more detail and produced a number of recommendations, most of which have not been adopted by the United States state courts, but to some degree in civil cases, in criminal cases in the United States, there has been some movement in that direction. Now, the notion of junk science, I suppose, really can be developed through two cases in the United States. Fry's case in 1923, which held that basically lie detector tests were not admissible in American federal courts. And the really important decision, civil case Daubert and Merrill Dow Pharmaceuticals in 1993, Daubert introduced for the first time a reliability condition. You could not lead opinion, evidence, and scientific matters without passing the threshold of satisfying a judge that scientific standards had been met, standards of reliability. Now, the position in most other countries that follow the common law, Canada, New Zealand, the United Kingdom, is that reliability criteria have been introduced into the opinion evidence admissibility test. We in Australia at present do not have a reliability criterion. Justice Bell has referred to section 79 of the Uniform Evidence Law, and I'll come back to that in just a few moments. We know that some forms of scientific opinion evidence which were the subject of strong criticism by the 2009 report are routinely used in Australia, admitted into evidence. That's not a bad thing, and I do not make the claim, and I do not suggest for one moment that evidence of the kind that was criticised should necessarily not be admitted. It seems to me there's a more nuanced approach that needs to be taken here. Some forms of evidence of that kind should not ever be placed before a jury. Other forms of evidence of that kind should be the subject of strong direction and powerful instructions about the limitations associated with evidence of that type. So again, I'll come to that now as I deal with my second topic, which is trial judges as gatekeepers. A gatekeeper is necessarily somebody who closes the gate and stops the person from getting through. Well, that's the argument, that we ought to have a more active role played by trial judges in relation to scientific opinion evidence. Daubert suggests that that is the approach that's to be adopted. Daubert's approach has been strongly supported by Professor Gary Edmund, University of New South Wales, and by Chris Maxwell, the President of the Victorian Court of Appeal, who've written recently in the Australian Law Journal and elsewhere on this subject. I think that there is a case to be made for the introduction of a reliability criterion. Section 79, to which I referred a moment ago, and I'll just read out subsection 1. If a person has specialised knowledge based on the person's training, study or experience, the opinion rule, that's the rule excluding opinion evidence, does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. Now you'll note that there is nothing in that section which requires any kind of reliability test to be satisfied. There are other provisions of the Evidence Act which stipulate that reliability is a matter that a trial judge will take into account. For example, section 85 of the Evidence Act, which deals with the admissibility of admissions and confessions, has a reliability criterion, and the judge engages in that task, but not the opinion evidence provision. Professor Edmund says, it has become increasingly obvious over the past decade that the manner in which Australian courts admit, present, and evaluate scientific, technical, and medical evidence is in many ways inconsistent with the recommendations and advice of peak scientific and technical organisations. And he's a strong critic, I'm afraid, Justice Bell, of the High Court in this regard. He attacks two decisions in particular, Dasreef and the case of Honeysett, both recent decisions, or relatively recent decisions of the High Court, saying that they neglect to provide a proper analysis of section 79 and neglect to allow for a reliability criterion to be imposed. He describes the law in Australia as being effectively one of judicial guessing rather than based on the proper evaluation and understanding of its true reliability. And he notes, and I note in the paper, that we tried to get through the back door in a case called Tuitt by saying, well, we can't really introduce a reliability component into section 79, but what we can do is we can use section 137 of the Evidence Act, which is the balancing, I won't call it a discretion, but you balance up and weigh up probative value and unfair prejudice, and the trial judge can exclude evidence if the trial judge, in his or her opinion, thinks the evidence would be unfair to admit in those circumstances. Well, unfortunately, I note here I'll be a little bit critical of the High Court in a case called IMM. By a 4-3 majority, we just lost. The state of Victoria just lost, I'll say, because we were at odds with our colleagues in New South Wales. And the High Court in IM held that reliability is a matter for the jury, essentially. It's not a matter for the trial judge in the exercise of the Section 137 power. So we in Australia are a little bit hamstrung at the moment without legislation to allow reliability to be a condition of admissibility in the Dobert sense. We're on our own largely, it seems to be, in that regard. I note in one of the footnotes that the Supreme Court of Canada had a very interesting observation to make about scientific evidence. They said, when dressed up in scientific language, which the jury will not easily understand and submitted through a witness of impressive antecedents, such evidence is apt to be accepted by the jury as being virtually infallible and as having more weight than it deserves. And that's the great danger, it seems to me, of a lot of this evidence. It's not that it necessarily should be excluded, because it can have probative value. It passes the test of relevance, but it really needs to be very carefully explained, it seems to me, on the basis of the evidence, what its limitations are. Well, that takes me to my final point, DNA evidence, and my life with DNA has been unmitigated misery over the years. I've had to deal with it in addressing, in charging juries. I've had to cross-examine on it. I've had to rule on it. And I've had at least 5 or 6 cases where it's been a really contentious issue. You can't fight DNA, it seems to be, very easily in terms of the expert opinion that's being proffered. It's almost invariably going to be accurate and correct. You can argue about it being irrelevant. You can argue about the DNA having got onto the object in question in a legitimate manner. You can argue about the possibility of things coming into contact in a tainted way and so forth. In other words, a criticism of laboratory techniques. But DNA is, if fingerprint evidence was the gold standard, DNA is the super plutonium standard these days. But not all DNA. Mitochondrial DNA, which was the subject of strong criticism, I had to deal with that in a case called McNeil, which was the Norfolk Island murder, which some of you in the room will perhaps remember. And I had a difficult expert witness, very well qualified on the subject of mitochondrial DNA. In fact, that was her speciality. And she came along and gave evidence on a voir dire. And she said, all I can say is I will not exclude the possibility, I will not exclude the deceased and her maternal relatives as being donors of the 2 hairs of the deceased. I will not exclude. I said, what does that mean, madam? And she said, it means exactly what I say. I said, can you go a little further? Can you assist the jury? She said, I will not depart from that formula. That's the formula we scientists use. Now, I concluded at the end of the day that that was unhelpful, likely to confuse a jury, and I excluded her evidence. She was brought over from the United States, I should say, at vast expense to the prosecution, and I simply sent her back to the United States. Now, it wasn't her fault. There was a breakdown in, it seems to me, communication or understanding of the way in which juries can be assisted by that kind of evidence. And they certainly wouldn't be assisted by being told in bald terms she could not exclude the deceased and her maternal relatives. I've had any number of DNA experts come along and speak to juries about, I know I've only got a minute left, Justice Bell, speak to juries about the nature of DNA evidence and what its background and scientific pedigree is. I've always found that extremely unhelpful. I think that things have improved a little bit now that we can see, and you'll see in the paper, that DNA experts are now prepared to speak to juries in terms that they can understand, in terms of not just statistics, which are very misleading and can be unhelpful. We know about the CSI effect. I've had to explain that to juries in the past when I've let DNA evidence in. But the paper deals with some of my trials and tribulations with DNA evidence, and it concludes with the worst piece of opinion evidence I've ever struck, which I've mischievously put into the paper so that you can read it. for yourselves and understand where we're headed, possibly, unless we do something to ensure that juries are given the assistance that they properly need. Thank you, Justice Bell.
Thank you, Justice Weinberg. If we could now hear from Professor Balding.
He's there, and it's a great honour to be here. I want to start with a little bit about my background, just to give you a little bit of idea where I'm coming from. So, a very unusual career given my background studying mathematics. I went off to Oxford to do my PhD, but I ended up getting into genetics, and most of my research career has been related to genetics, including DNA profile evidence, and so that's brought me into contact with a lot of courts and a lot of lawyers, and I've really enjoyed that work. And once I was able to develop a relationship with some lawyers, they kept calling me back for different cases. So you can see I've done a whole range of different things thanks to my statistical expertise. It's one of the advantages of being a statistician is you get to play in everybody's backyard, because statistics comes up everywhere, as you can see by the range of the cases. And I've done a little bit of work advising the UK Forensic Science Service and the UK Forensic Regulator. So I've also, or just to mention that I have roughly equal experience in prosecution and defense in the criminal cases that I've worked on. Now, we already heard about this kind of bombshell 2009 US National Research Council report. They found serious deficiencies in all kinds of forensic evidence, and their sort of headline conclusion was, with the exception of DNA analysis, no forensic method has been rigorously shown to work. So that's quite devastating. I want to come back to that. The situation's not quite as bad as that suggests, but it certainly is bad, and we can look at some of the reasons. In 2016, there was a further report from the US, the President's Council, and they looked into these kind of match evidence where a person of interest is matched to a crime scene via hair, bullet, shoe prints, ear prints, all kinds of things. And they looked and found, again, serious deficiencies. They looked at 3,000 criminal convictions that used hair analysis and found terrible track record. So again, they had these sort of bombshell conclusions. Miscarriages of justice due to errors in forensic science are systemic and pervasive. So it's looking quite bad for the scientists in general. How can this be so? I'll come on to that, but let me just go a little bit more. They're particularly focused on bite mark evidence, and the story. There's a great article on this in the Virginia Criminal Law Review, I think, that kind of details the very, very sorry story of bite mark evidence in courts, and a kind of complicity between courts and forensic scientists, I would say, to deceive each other and not really ask the hard questions. So the professional, the expert witnesses were well qualified. They were members of professional societies. So just going on qualifications wouldn't have got you anywhere. And yet, PCAST, when they looked at it, that's that US President's Committee, found that the experts, when tested, couldn't even identify that it was a human bite mark, let alone who it came from. And unusually, in most other cases, they said, we need more research, we need more research. In this case, for bite mark evidence, they said, don't bother doing more research, it's hopeless. And you can see some bad consequences. I mentioned many exonerations, subsequently, many of them through DNA evidence, exonerating defendants that were convicted on the basis of bite mark evidence. You might be thinking, well, fingerprint evidence, that's already been mentioned, surely that's reliable. And in a sense it is. And there was really good science done way back in the 19th century by Galton. And the key thing is that he quantified the weight of evidence. And I think that's really key, because fingerprint evidence is good evidence. But unfortunately, a desire to oversimplify led to this kind of myth of the infallibility of fingerprint evidence. And I mean, when you just have to think about it for a moment, that any kind of evaluation of the evidence that's categorical, that, yes, it was him without a shadow of doubt, that's not going to work, because the uniqueness of individual fingerprints doesn't matter. What matters is the quality of the mark left at the scene of the crime. And the mark is going to vary. And so some of them are going to be really easy, and some of them are going to be really hard. And once the evidence starts getting accepted in court, you know, human nature being what it is, people are going to be tempted to push the limits and push the limits, and you're going to get errors. And that's exactly what happened famously in the Madrid bombing case. I don't know if you know that story, that the FBI identified the wrong person. They identified a man they said was the source of the fingerprint. The Spanish police looked at it and said, no, we don't think so. But the FBI insisted it was a big embarrassment for them. In any case, it's not that fingerprint evidence is bad. It's, in my view, that you have to go back to Galton in the 1890s and be quantitative about it. How strong, how good is the match? And any kind of categorical yes-no system is not going to be good enough. We've had our own miscarriages of justice due to errors in forensic science in Australia. The Chamberlain case was a national disgrace. The Jama case in Melbourne just recently finished. The Eastman case in the ACT, gunshot residue evidence was largely responsible for his conviction, said to be a match between gunshot residue in his car versus the scene of the crime. But on appeal, eventually gunshot residue evidence has been discredited. Eventually he was found not guilty at a retrial. So of course, there are big questions here. Why haven't the courts demanded good science, and why hasn't science corrected itself in the way that we scientists like to think that we're good at? And of course, I can't really answer these questions, and I can't speak for the courts, but I can speculate on a few things. But I would like to emphasize this overemphasis on authority rather than the facts of checking ability. So, and I would do a comparison sometimes with medical experts. There was a movement called evidence-based medicine a decade or two ago, and many people would have thought, what do you mean? Surely medicine is evidence-based, but a lot of clinical practice wasn't evidence-based. It was very much focused on the authority of a distinguished clinician, and the distinguished clinician was good at many things in many cases, but there was a temptation to go beyond the expertise, leading to errors. And I think that's one source of the problems we're talking about here. Another source is the forensic scientists were using techniques that were often good for investigations, but really not appropriate for a key part of evidence in trials. So one of the issues I've also highlighted here, that forensic scientists don't work the same way, you know, that a good scientific culture is a delicate thing, like democracy. It has to flourish in the right environment, and the environment of many forensic scientists isn't very open to scrutiny in a way that's really, really crucial. But again, we've heard something about this gatekeeper role of courts. Once a court admits some evidence, often the initial use of the evidence was somewhat cautious. But after some successes, there tend to be there's a kind of spiral of the forensic scientists think, well, this has worked in the past, so there's no onus on us to do any more work. And similarly, the courts might be thinking, well, you know, this has been used successfully in previous cases, so we won't scrutinize it too much this time. So all of these things have led to, you know, I think I want to emphasize that all the lawyers and all the forensic scientists I've worked with are good people trying to do a good job, and yet many mistakes are made because of these issues of culture. And where is the onus? Where is the incentive on people to do better and to scrutinize in a really, really challenging way? But I'd also like to emphasize that things are getting better. There is progress. I'll say a bit more in a moment. You know, I don't have time to tell the whole story, but I would put a lot of weight on the effect of DNA evidence. Much of this other kind of evidence is of a sort that other scientists aren't that interested in, gunshots and bullet marks, and it doesn't come up in normal science. But DNA evidence was cutting edge science that scientists were interested in, and it attracted scrutiny, a lot of controversy in the scientific world, and that spilled over into asking similar questions in other forensic disciplines. And so that's what led to this National Academy of Science report, and that's had consequences. So in the UK, where I've had most of my career. So I just emphasize again, I'm not that familiar with the Australian system. The introduction of the forensic science regulator has really helped in establishing standards. There was a law commission recommended some principles for expert evidence that got converted into a practice direction from the Lord Chief Justice. A lot of emphasis in that on reliability, and their very first criterion was to look at the extent and quality of validation data, which is what courts haven't done sufficiently in these previous cases. In the US, we've heard these Daubert admissibility hearings, and again, the importance of an admissibility hearing is that it sets a standard and a challenge that puts an onus on forensic scientists to do better, although they're not always successful. And there was a National Commission on Forensic Science which was doing good work, unfortunately closed for reasons you can guess in the current climate. Very unfortunate, but the cat was out of the bag a little bit. We've seen there are some cases I cite here of federal judges questioning fingerprint evidence for the first time, questioning ballistics evidence that has been introduced in thousands of cases, but now really asking for, you know, what's the evidence that it works, and finding it deficient in some respects. So what about Australia? Well, we've heard that Australian judges are different from my experience in the UK and the US, where there's very little gatekeeper role for the judge. That challenges to scientific evidence must be made in front of jurors. You know, there's a lot to discuss about that. There's many reasons why I think that's unsatisfactory. But one thing is that the jurors never pronounce, let alone whether they're capable of judging the science. Even if they did, they don't tell us what they made of the science. They just give a guilty or not guilty verdict. Whereas in a challenge, in an admissibility hearing, there is an outcome. Yes, that evidence is judged to be good enough, or it's not. And that kind of feedback really helps the system, or can help the system improve. I've had a little bit of involvement with the Forensic Evidence Working Group in Victoria, which did some good work improving practice with relation to pre-trial meetings of expert witnesses and this kind of thing. There's a National Institute of Forensic Science, which has been doing good work. I must admit, I'm not close. Unfortunately, it's very limited in size compared to the size of the problem, but they're trying to set standards. I just took some keywords there from their website about the sorts of things that they're trying to do to improve. And there are improvements going on, and many of the criticisms of the science we've been hearing are no longer completely valid, but we've got to keep everyone on their guard, of course, and not relax and keep the pressure on for high quality. Now, there's some emphasis on reliability and whether these admissibility hearings really work. There is some doubt about that, their effectiveness. And I want to say, you know, I've spoken up some advantage of them, but I think we can't get away from, as I was saying, with fingerprint evidence, the importance of evaluating evidence. And that's inevitably gonna, particularly given my background in mathematics, gonna involve some numbers to assess the weight of the evidence, and in a way that takes the sources of uncertainty into account. And when we start to directly and openly analyze the sources of uncertainty, many of these problems will go away. And of course, openness to scrutiny by a wide public is a major issue. I'd just like to highlight as a kind of illustrative example, my work on the famous bones of King Richard III. There were a lot of scientists working on this. They did all kinds of different scientific work. They amassed a ton of evidence, and they didn't really know what to do with it. And I came along with colleagues, and we started, you know, looking for data, sources of error, trying to put numbers on these things. Now, a lot of judgments involved in that. There's far from perfect, and there was plenty of kind of openness to criticism, and there was a huge interest in this case. So there were critics jumping up. But once we did this, you know, very open, detailed, quantitative analysis, basically we just silenced our critics. That I was a little bit surprised in the end that nobody really challenged, because the evidence overall was overwhelming. And what's really interesting in this case is that no one piece of evidence was decisive. There were several different kinds of evidence that all had to be combined to come up with the overall weight of evidence. And so I've done a lot of work with trying to quantify the evidence in messy, noisy DNA profiles. So I just kind of show you a bit of an example here. There's contamination, they're hard to replicate, but nevertheless, if analyzed appropriately in an open scientific way, building in sources of error and variability, is never going to be perfect, but even this kind of messy evidence can be much stronger than traditional forms of evidence. So then we have the problem of what do we do with these problem of numbers in court? And this was a big issue when I first, right back at the beginning of DNA. If we had a DNA evidence and it's said to be 1 in a million chance or 1 million times more likely, what does this mean? And for the first few years, scientists hadn't come across this problem. And I have to say, scientists weren't very good at evaluating evidence and putting meaning to these numbers. There were very many famous scientists that said silly things, that said they didn't understand. But we now do, and we can explain with pretty easy examples. Well, if your evidence has a value of 1 million, then if there's 10 million possible sources of the DNA out there, then that's not good enough to be sure we've got the right one. But if there's only 1,000 possible sources of the DNA out there, then it's 99% sure. And I've been, giving numerical quantitative evidence like this in UK courts. I think it's gone pretty well. Of course, it's hard to get feedback from the jurors. I will just, skip this slide because probably my time is up. And I want to acknowledge the help I got from Gary Edmond, who provided his paper in the Australian Law Journal, and Justice Maxwell, who provided his paper, and the Evidence-Based Forensics Initiative in Wollongong. And I mentioned here shamelessly my book, where I go into a little bit more of these issues I've been talking about today. So
on that shameless note, Professor Balding, thank you very much for that presentation. And if we can move next to Professor Vinuesa.
Thank you, Justice Bell. So in April last year, I participated in the inquiry into the convictions of Kathleen Folbig. My colleague, Professor Matt Cook, and I were asked to act as unpaid expert witnesses. I was approached by Ms. Folbig's solicitors, while Matt was approached by the Crown Solicitor for New South Wales. Together, we wrote a joint report for the inquiry. I have not been involved in any other legal proceedings before, but I want to talk to you about my experience as a scientist expert witness. You may wonder what insights a first-time expert witness may have about legal proceedings, but I think it is exactly my naivety that allows for such insights. While the legal system has an unparalleled ability to draw and distill information from varying sources, my experience left me thinking it has several blind spots when it comes to evaluating scientific evidence. I readily acknowledge that my observations come from a sample of an N of 1, so where my experiences are not indicative of usual practice, please feel free to discard them. My hope is that by engaging in discussions like this, we can build a more scientifically sensitive and informed legal system, one that is not only skilled in applying the scientific method, but also welcoming of scientists. Before delving into my observations, I think it is necessary to provide some context about the case. Kathleen Folbig is a woman from the Hunter region of New South Wales. She and her then husband, Craig Folbig, had 4 children that died over a period of 10 years in the 1990s. The children, Caleb, Patrick, Sarah, and Laura, all died while asleep at varying ages, ranging from 19 days to 18 months old. In 2003, Kathleen was convicted of the manslaughter of Caleb and the murders of Patrick, Sarah, and Laura. The jury was persuaded by the prosecution's case that Kathleen had smothered her 4 children. There had been no history of abuse and no physical signs of smothering. The circumstantial evidence against Kathleen consisted of coincidence evidence and diary entries. The coincidence evidence was that it was extremely rare for multiple SIDS-like deaths to occur in a family, while the diary entries were considered to contain inculpatory statements as they expressed sentiments of remorse and guilt. Kathleen has always denied smothering her children and claims the sentiments reflected in her diaries were interpreted wrongly. At the time of the trial 17 years ago, genomics was in its infancy, and the geneticists involved in Kathleen's case could not find a genetic cause for the deaths of any of the children. Instead, the sentiments of infamous British pediatrician Sir Roy Meadow influenced the discourse about multiple familial SIDS deaths. Meadow's now notorious maxim stated that 1 SIDS death is a tragedy, 2 is suspicious, and 3 is murder until proved otherwise. Meadow has since been discredited by statisticians and scientists, yet his suspicion of multiple familial SIDS deaths appears to have lingered in the wider medical and legal community. In all 4 Folbig children, there was medical and pathological evidence that pointed towards natural causes of death. Caleb had difficulty in breathing and swallowing, Patrick suffered from epilepsy and blindness, and prior to their deaths, Sarah had a bacterial lung infection and Laura had myocarditis. Kathleen herself suffered several episodes of fainting suddenly that were witnessed, including an episode during a school swimming race where she was dragged out of the pool. Fainting in this manner is typical of cardiac arrhythmias that can cause sudden death in infancy and adulthood. In early 2019, I was asked to form part of a team of geneticists to analyze the genomes of Kathleen and her 4 children. From a technical perspective, it was an incredible achievement. The Victorian Clinical Genomics Service sequenced entire genomes from neonatal heel prick blood cards that were over 20 years old. We performed bioinformatic analysis of the approximately 3 billion base pairs of DNA for each subject. Unfortunately, the analysis was hindered by the fact that Craig Folbig, the children's father, declined to provide his DNA. I assumed the inquiry would compel Craig to provide a saliva sample as we requested, but he declined to make such an order. Despite this disadvantage, we found a novel, never before reported mutation in Sarah and Laura that had been inherited from Kathleen. The variant was in a gene called CAM2 that encodes for calmodulin. Calmodulin variants can cause sudden cardiac death. After the end of the hearings, but before the inquiry made its findings, an internationally peer-reviewed article was published containing a registry of 74 people with variants in calmodulin genes. Of those, 20 had died suddenly, 5 of them during periods of sleep, of which 3 were less than 2 years old, just like Sarah and Laura. One boy who died at age 4 and his brother who suffered a cardiac arrest at age 5 had a calmodulin mutation at the exact same amino acid location as Sarah and Laura. The boys had also inherited the mutation from their seemingly healthy mother. Our team reached out to the senior author of the paper, Professor Peter Schwartz, a cardiologist and the world-leading authority in genetic causes of cardiac arrhythmias and sudden unexpected death. Professor Schwartz reviewed the clinical and genetic information of the Folbig family and wrote to the inquiry indicating the CAM2 variant was the likely cause of Sarah and Laura's deaths. The inquiry rejected Professor Schwartz's assessment, finding the inculpatory interpretation of the diaries to be more persuasive. In reaching this conclusion, the inquiry relied on evidence from another group of clinicians, including the sole cardiologists that attended the inquiry. The other group of clinicians emphasized the fact that the genetic evidence did not explain the deaths of Caleb and Patrick. The sole cardiologist also made several incorrect statements about the effects of calmodulin variants that could have easily been checked by contacting the authors of the CAM registry paper. Since the conclusion of the inquiry, in which the judge ruled against reopening the case, Professor Michael Toft Overgaard from Denmark, in collaboration with calmodulin experts from US and Canada, performed a series of experiments on the CAM2 variant. The findings have been published today in the Oxford journal Europace. The 27 authors conclude that the calmodulin variant likely precipitated the deaths of Sarah and Laura if their deaths were natural. As a scientist and medical doctor, I found the procedure of the inquiry bewildering. Even before Professor Toft Overgaard's team and collaborators completing their experiments, there was credible medical and scientific evidence to indicate the Folbig children had died of natural causes. For instance, all the forensic pathologists involved in the inquiry considered Laura's myocarditis to be sufficiently severe to have caused her death. Myocarditis is known to trigger cardiac arrhythmias, and our genetic findings showed that Laura had a mutation in a gene associated with cardiac arrhythmias. 3 of the 4 pathologists went further and said they would have recorded myocarditis as